How are assets divided up in a divorce is a question that most people want to know, especially if they have a lot of assets. You should know that anything that is acquired during the course of the marriage in the state of Ohio is marital property. If the two of you purchased a home together during the marriage, that is a marital asset. If one of you has built up a large amount of money in a retirement, a 401k or an IRA, if it happened during the marriage, that is a marital asset. If one of you purchased a business and grew it during the marriage, that is a marital asset. The rule of thumb is equal, but really what's more important than equal is equitable, meaning what is fair. But you should know that just because the asset is only in your name, that doesn't mean it's not marital. This happens. A husband who has a business that only he runs, but that he purchased or began running during the marriage, the wife is entitled to a share of that business. In the same way, if a wife has been putting lots and lots of money into her retirement account over the course of the marriage, and the husband has not accumulated any money, that money in her retirement account is an asset of the marriage, and he is entitled to half. The courts do not necessarily give you half of each individual thing. It's more of what you'd call a balance sheet. So one asset can offset another asset. Maybe the husband wants to keep the house, and the house has $20,000 worth of equity in it. Technically, the wife would be entitled to $10,000 worth of that equity. But maybe the wife doesn't want the house. What she would rather keep is her retirement, which is $20,000. And so, instead of giving the husband $10,000 of her retirement account and the husband giving her $10,000 out of the equity in the house, she would just keep her $20,000 in the retirement, and he would keep the $20,000 of equity in the house. Assets also include household furniture, the pets, and unfortunately, the children. But all of these things do have to be divided up in the divorce. So ideally, you and your spouse can come up with a plan that is fair to the two of you, that each of you thinks is fair, and that's the way that you can divide up assets. Everybody doesn't always necessarily want half. Sometimes one spouse is just like, look, because the assets in this case are actually debts, right? Because you have to divide up the assets and the liabilities. Sometimes one spouse is just like, look, you can have the house. You can also have all the credit card bills, you can have it all. You can have everything that accumulated during this marriage. I just want to walk away scot-free. That's also a reasonable way to divide up the assets and the debts in a divorce. If, however, the two of you cannot come to an agreement and this matter ends up going to a trial, because note, there's only two ways to get out of a marriage. Either you reach an agreement or a judge makes a final decision. A judge can't make a final decision without a trial, so you agree or you go to trial. If you can't reach an agreement and you have to go to trial, the assets are going to need to be evaluated, meaning there's going to need to be a clear number put on what each of these assets are, like what each asset is worth. And then it'll have to be determined which assets are definitely marital as opposed to assets which might be separate property, which would be assets that were acquired before you were married, or maybe assets that you acquired due to an inheritance. Those would be separate. So these different designations have to be given to the property, and then the court will make a decision how to divide them up.